Major breaking news. There are now 2 cases pending before the U.S. Supreme Court asking the question of whether or not, under the Second Amendment, states can ban semi-automatic rifles such as the AR-15. The answer undeniably is no, by the way. With that said, there are 2 pending cases up on cert. One is the Benitez versus Cook County case out of the U.S. Court of Appeals for the 7th Circuit in Chicago. The other is the Grant versus Lamont case and the National Association for Gun Rights versus Lamont case, both arising out of Connecticut's assault weapon ban through the U.S. Court of Appeals for the 2nd Circuit in New York City. Both the 2nd Circuit in New York City and the 7th Circuit in Chicago screwed this up completely. And these cases are now before the Supreme Court with an opportunity for the court to step up and grant cert and resolve these questions once and for all in our favor, which is what's going to happen. But with that said, I put together an extremely detailed, geeky video. This is a pro-level class, folks. This is a master class in understanding and how to explain and defend the historical tradition of regulating so-called dangerous and unusual weapons and the meaning of in common use. But this is going to get geeky. I'm warning you now to be the smartest person in the room, though. If you want to argue that the National Firearms Act is unconstitutional in part, if you want to argue that AR-15 should be protected by the Second Amendment, you have to watch this video because this is pro-level stuff and you need to understand what I'm about to say here, where I put all the different knots together. I put all the strands together and tie them up in a nice bow for you so you understand how to be the smartest person in the room when it comes to discussing dangerous and unusual in common use and whether or not AR-15s can be banned under the Second Amendment. You need to know this, folks, because this issue is coming to the Supreme Court very, very soon. Stay tuned. Hey, folks, I'm Mark Smith, host of the 4 Box and Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we're going to have to break this down and get geeky here. As you know, there was a big argument this week in the United States Court of Appeals for the 3rd Circuit en banc over whether or not the state of New Jersey can ban AR-15s, semi-automatic rifles, and magazines that hold more than 10 rounds. Part of this argument, of course, turns on what is the standard? What is the legal test? As I explained in the Harvard Journal of Law and Public Policy in extreme detail, and I'm completely right, and I'm highly confident the U.S. Supreme Court will agree with Mark Smith, even if the lower inferior courts who hate guns won't follow the law and won't follow the teachings of Mark Smith, I will be vindicated in the end, I suspect. We will see. The history of the future is yet to be written. So with that said, let's break down in a professional, serious way, what exactly is the legal test, the constitutional standard for determining whether or not a particular type of arm is protected by the Second Amendment in today's world. I'm not going to give you fantasy land or what I want to occur. I'm going to try to tell you what I think will occur if the Supreme Court ever takes one of these cases again and resolves these kinds of questions. You can disagree with me, but I suspect I'm ultimately going to be vindicated, but of course, only time will tell. So to begin with, let's start with the basics. We know that the Supreme Court in the Heller case in 2008 has already defined what an arm is. An arm is anything that can be used offensively or defensively. That could be anything, right in and of itself, right? That would include, definitionally, machine guns, semi-automatic rifles, grenades, could include clubs, could include any kind of edged instrument, any kind of knife, axe, and so on. All of these things could be arms. We also know that the Supreme Court, by virtue of the text of the Second Amendment, the right of the people to keep and bear arms, the right to bear, or to bear, means to carry. So the Supreme Court basically says that the Second Amendment's text covers any bearable arm, which eliminates things like, let's say, battleships or F-16s, fighter planes, because you cannot carry those kinds of arms. The Second Amendment is about bearable arms, because it's the right to keep, which means to possess, and the right to bear, which means to carry. And nobody I know knows how to carry themselves a battleship or anything like that, or an ICBM. So with that said, the Supreme Court has talked about what kinds of arms are protected on the Second Amendment. In some respects, the way to really ask the question is what kinds of arms are not protected under the Second Amendment. Now, to step back briefly and talk about the National Firearms Act, because this is very important. Many people just mouth the words that the NFA is unconstitutional, that the National Firearms Act is unconstitutional. And in some theoretical fantasy land, that may be true. But in the real world in which we live, with real judges and the real Supreme Court, the answer to the question of whether or not the National Firearms Act is constitutional, it requires a more nuanced answer. It just does. And that's because the Supreme Court has made it clear over and over and over again that, for example, machine guns are not protected under the Second Amendment. So no matter how many times you want to disagree with that or argue about that, that's fine. But the truth is the Supreme Court rejects those arguments so far. Maybe in 10 years, the composition of the court will change and the analysis will change. But for now, machine guns are not protected arms under the Second Amendment. And as I've explained to you before, they won't be. Now, the reason why I bring this up is when you argue whether or not the National Firearms Act is constitutional, you need to be more precise. Parts of the NFA is constitutional, parts of the NFA is not, under current Supreme Court case law. For example, I think that things like grenades, shoulder-fired missiles, mines, machine guns are not protected under the Second Amendment, based on what the Supreme Court has said and has indicated. You may disagree with it, but I'm telling you what the Supreme Court has said and has indicated, and for now, they're the bosses. They tell us what it means. That's what it is. And if you have one of these items and you don't follow the law, you get to go to prison. So there are real consequences to disagreeing with the Supreme Court in the real world, even though we may personally disagree with that assessment. This is the world in which we now live. Now, the reason why I say this is we have to be able to explain how is it the case that some of the weapons identified, some of the arms identified in the NFA are protected under the Second Amendment, and some of those arms are not protected. Because here's the thing, folks. If an arm is not protected under the Second Amendment, then basically the government can do anything it wants to it. What I mean by that is, if, let's say, machine guns are not protected under the Second Amendment, and the Supreme Court has indicated they're not, then Congress could constitutionally, consistent with the Second Amendment, ban machine guns, period. Likewise, they could say you can't register them under the NFA. That's over, period. They could theoretically do that consistent with the Second Amendment. Now, we're not going to talk about issues with Article 1, whether they have the power to do so under their authority. That's a separate question. I'm just talking about as a matter of Second Amendment law. So when you assess whether or not a part of the National Firearms Act is constitutional or not, you have to ask yourself, what is the item that we're talking about? And if it's mines, if it's grenades, if it's machine guns, shoulder-fired missiles, handheld shoulder-fired nuclear weapons, these are likely not protected under the Second Amendment. And because they're not protected under the Second Amendment, Congress or the legislatures can do basically anything they want with those kinds of items because they have no Second Amendment protection. So the question is, how do we live in a world where handguns are protected on the Second Amendment, semi-automatic rifles, AR-15s, AK-47s are likely protected on the Second Amendment? I think that's pretty clear. The Supreme Court has to say that because there's lower courts that misbehave, but I think that's what the Supreme Court will ultimately say. So the question is, how do we draw this distinction as intellectual scholar, legal experts, lawyers, between what is protected and what is not protected under the Second Amendment? And I think this is the way to do it, to square the circles. To begin with, going all the way back to the 1939 decision of the United States versus Miller, which is actually favorable to the Second Amendment because, as you know, in Miller, they said that short barrel shotguns are not protected under the Second Amendment because there was no evidence or discussion in the record of why they would be protected under the Second Amendment. But the reason why the Miller case is actually favorable to the Second Amendment is because it reaffirms what we always knew, which is that the Second Amendment protects an individual right. Because think about this for one moment. If Frank Miller, who was convicted, and there's the name of United States versus Miller, right? If the Supreme Court thought that only members of the militia, only people participating in some sort of collective defense could be protected under the Second Amendment, they could have just decided the Miller case in a paragraph. They could have written that Frank Miller, the defendant in this case, is not a member of any organized militia, and therefore he loses this case because he had a sawed-off shotgun. He's not allowed to have that. He's not tied to a militia. Game over. But that's not what the Supreme Court did in Miller. Instead, the Supreme Court in Miller assumed that Mr. Miller had a right to keep and bear arms, and they analyzed whether or not he had a right to keep and bear a sawed-off shotgun and concluded, based on the record, that he did not have that right. Again, if the Supreme Court was going to conclude in 1939 there was no individual right to bear arms, they would have just said he has no individual right to bear arms, he's not connected to a militia, he has a gun, he can be convicted under the National Firearms Act, end of story. But the Supreme Court did not say that, and that, of course, is reaffirmed by the 2008 Supreme Court decision in Heller that reaffirmed that the Second Amendment protects an individual right to keep and bear arms and not a collective right, not a militia right. So that's all very good here. But the other critical thing that Miller talked about that the Supreme Court in Heller reaffirmed is that there is a right to bear arms that are in common use. The critical language in Miller, which is cited and discussed in Heller in 2008, is this, that ordinarily, this is a quote from Miller, ordinarily when called to service, these men, Americans, were expected to appear bearing arms, carrying arms, bearing arms, supplied by themselves, and of the kind in common use at the time. So for those of you who want to know where the phrase in common use comes from, it originally comes from the 1939 Supreme Court decision of the United States versus Miller, pointed out that militia members at the time of the founding would bring their commonly owned firearms and weapons with them to militia musters. So at a minimum, arms that are in common use by Americans must be protected under the Second Amendment. That discussion was reaffirmed and quoted in 2008 by the U.S. Supreme Court in the United States in the District of Columbia versus Heller case, which again reaffirmed that weapons that are in common use are protected under the Second Amendment. By the way, that does not mean that weapons that are in common use are the only kinds of weapons that are protected under the Second Amendment. It's just saying that if a particular kind of bearable arm is indeed in common use by Americans for lawful purposes, that arm is indeed protected under the Second Amendment. It's sufficient to be protected, although not necessary. There may be other weapons out there that are not in common use that can still be protected under the Second Amendment. But when we're talking about the kinds of things we're talking about today, AR-15s, AK-47s, magazines, suppressors, and so on, these are so ubiquitous that they're clearly in common use. You don't have to worry about any of these other tests. But I want to talk about what may be other tests with new weapons down the road here and now. Because to understand the big picture, I want to break it down for you as I kind of see it. And maybe you disagree with me, and you'll tell me why you disagree with me. So with that said, there is the in common use test that says that if a weapon is in common use and it's bearable, it's protected under the Second Amendment. But then the Supreme Court in 2008 kind of reaffirmed the notion that the in common use test is really the flip side of a historical tradition of firearms regulation. And this is very important to listen to, folks. In the Heller case, the Supreme Court specifically said that dangerous and unusual weapons, these are conjunctive, are basically protected arms. And this is what Justice Scalia wrote. He says, we think that the limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. And they cite to many different authorities. So to the extent some lower inferior court, of which there are many, including the U.S. Court of Appeals or the Second Circuit out in New York City, tries to play games and say we think it's dangerous or unusual, that's total BS, because the Supreme Court has already ruled on this and written expressly that the test is dangerous and unusual in Heller. So to change out the and for or is frankly judicial malfeasance, which we see in these inferior courts every day all across America because they're simply anti-gun judges who are political partisans wearing black robes. That's the harsh reality of it. So then it turns on the question of what exactly is dangerous and unusual and how do we understand this? And I'm making this a slightly longer video because this is very important because it's very nuanced and sophisticated legal argumentation. And I want you to be the smartest person in the room so you can defeat professors at Harvard and other scholars and whatnot by making the best possible arguments based on the facts and the information I provide to you. I don't just train you, in my view, to beat up on some guy at a local bar. I want you to be able to defeat serious anti-gun lawyers with the arguments I provide for you. That is the standard that I set, and I expect many of you to satisfy. And I'm sure many of you have exceeded those. So let's go back to the question of dangerous and unusual. What does dangerous and unusual mean, and how do we apply it, given the fact that we know the Supreme Court has indicated things like machine guns are not protected, but other guns are? How do we analyze and square these circles? So now let's take the phrase dangerous and unusual and break it down in detail. The first thing, of course, is to be able to argue is the word "and" is indeed in the text, or is the relevant text. It's dangerous and unusual, not dangerous or unusual, or some other basically modification or change. And appears specifically in the U.S. Supreme Court case of Heller, cited in many different authorities. And we know that to the extent there's a single edition of Blackstone's commentaries that says dangerous or unusual weapons. And keep in mind that Blackstone is an English lawyer interpreting English law. And we know for a fact that the United States Second Amendment has a broader individual right than the English have. Keep in mind that under English law, as articulated by Blackstone, the right to bear arms was only protective of the right of Protestants to bear arms. It did not give Catholics the right to bear arms. We in the United States have a broader understanding of the right, and we allow the people, as in the right of the people, to keep and bear arms. So it's broader than the English right, which only extended to Protestants. We extended to all Americans, all of the people. Moreover, we also know that the English Declaration of Rights only bound the king. It only prevented the king, the crown, from taking away weapons and reducing Second Amendment right, well, what would be essentially their version of Second Amendment rights, the right to bear arms in England. That did not prevent the Parliament from changing the law. So again, we in America, with the Second Amendment through the 14th Amendment, prevent all forms of government from violating our Second Amendment rights, whether it be the federal government, state, or local governments. Again, a broader understanding of the right to bear arms than the English have or ever had. So to the extent you want to say that Blackstone said dangerous or unusual and it wasn't a typo, the reality is it doesn't matter because the American understanding of the right is broader than the English understanding, and William Blackstone was talking about the English understanding, which again is more narrow. But none of this really matters because the U.S. Supreme Court, which is the height of American law, says dangerous and unusual. So lower inferior courts have to follow that conjunctive test. So the first thing is that in dangerous and unusual, the word "and" means exactly what it means, conjunctive. For an arm to be restricted or banned or otherwise regulated or taxed and unprotected under the Second Amendment, it has to be both dangerous and unusual. Now, we've talked about the word "and." Now let's talk about the word "unusual." We're not going to belabor the point on this because you know what I'm going to say. If an arm is in common use by Americans for lawful purposes, by definition, it is not unusual, right? And if it's not unusual, it cannot be banned because it cannot be dangerous and unusual. So again, that's pretty straightforward. So now we've just talked about the meaning of the word "and," which is conjunctive, and the meaning of the word "unusual," which is not common, atypical, uncommon, whatever you want to say. So what about the word "dangerous"? Now here's where we're going to have to get a little geeky. You'll understand when I break it down. What does dangerous mean? Dangerous and unusual. Well, dangerous has to mean something more than just dangerous. Why do I say that? We know that textually the word "arms" means anything that can be used offensively or defensively. We know that all arms are by definition dangerous to someone. That's what makes them arms, the ability to use an arm to hurt someone else so you can protect yourself or whatever it is you're doing, wage war on them. So dangerous and unusual, the word dangerous has to mean something more than just dangerous because a weapon or an arm by definition is dangerous. So if you write the sentence, "a dangerous and unusual arm," the word "dangerous" has no meaning. It's been rendered nugatory, which means irrelevant. And when you read a legal document or a legal statute or a legal contract or a constitution, one of the basic rules of legal interpretation is that you're not allowed to render a word nugatory, which means irrelevant, or to read it out of the law. So the phrase "dangerous and unusual," we've defined the word "and," we define the word "unusual." Now, with respect to dangerous, what do we do with that? If it is the case that a dangerous and unusual weapon is redundant because a dangerous weapon is exactly the same meaning as a weapon, how do we handle the word "dangerous" in the phrase "a dangerous and unusual weapon" or "a dangerous and unusual arm"? And I think the proper way to understand this is that you have to modify the word "dangerous" with the word "unusual" So it has to be an unusually dangerous weapon, and it has to be an unusual weapon before you can subject that weapon to a ban or a tax or some other major restriction. Because the only way you take a bearable arm out of the protection of the Second Amendment is, in my view, based on my analysis, which we'll continue on with in a moment, the weapon has to be unusually dangerous and conjunctive, an unusual arm. So it must be both an unusually dangerous arm, and it also must be an unusual arm. Both of those tests must be satisfied by the government. And just to jog your memory, because the dangerous and unusual arms test, or constitutional standard, arises from history, from the historical tradition of firearms regulation. Why is that important? It's extremely important because the burden is on the government to demonstrate that an arm is dangerous and unusual. The burden is on the government. That means the Second Amendment rights claimants have no obligation to come forth and argue or prove that a weapon is not dangerous and or not unusual and or in common use, because the burden is on the government, because the test is a historical test, and once the burden shifts to the government to perform history, that means the burden is on the government in all respects to show that this weapon is indeed dangerous and unusual as defined. Okay, now let's carry on. And I know we're breaking this down slowly, but this is a very important point and a very geeky point, and important to understand because there's a lot of misunderstanding out there, and I'm breaking it down for you. I think the way the Supreme Court completely would agree with me. And I think they will articulate this hopefully in the next year or two when they take an AR-15 case, as Justice Brett Kavanaugh indicated they intend to, or at least he expects them to. So now that we've talked about that a weapon to be banned has to be unusually dangerous and conjunctive, an unusual arm in society, how do we understand what is the word unusually dangerous? How do we figure this out? What makes something dangerous, which is an arm, versus what makes something unusually dangerous? What is the difference? And the answer is, I think, not how it is misused. Every arm can be misused. Every arm can be engaged in a mass shooting. For example, we know in Virginia Tech in 2007, a year before the U.S. Supreme Court decided Heller, a handgun with magazines that held more than 10 rounds were used to kill over a dozen people and injure more at Virginia Tech. This was understood and known about by the U.S. Supreme Court when they decided Heller in 2008 because the Virginia Tech shooting not only occurred in 2007 before Heller, the Virginia Tech shooting was literally litigated in the amicus briefs in the Heller case itself. So whatever unprecedented social changes or whatever these things you want to call these things are, it cannot be mass shootings with commonly owned firearms because that was not unprecedented in 2008 when the Supreme Court decided Heller. So that means, again, going back to the question, what is an unusually dangerous weapon in the context of the dangerous and unusual arms standard? And I think the answer is ultimately this. It turns on the high likelihood of collateral damage from the normal and typical use of a weapon. What do I mean by that? Well, let us look at the NFA for different kinds of items that might fall within the definition of bearable arm that are likely bannable under the Second Amendment, the Supreme Court's interpretation so far. Hand grenades. If a bad guy walks into the room and I throw a hand grenade at him, I'm likely going to get him. But the problem is the nature of hand grenades or bombs are that you have a high likelihood of collateral damage, meaning that people around the bad guy are likely to be injured by virtue of the mere fact of me using a hand grenade or a bomb. The collateral damage is not really controllable in a fair or useful way by the user of the arm. And therefore, that is unusually dangerous. And, of course, not a lot of people own hand grenades or bombs, so it would also be an unusual, i.e. not a common arm. So I think that's an example of an unusually dangerous arm that is also not in common use by Americans for lawful purposes, and thus hand grenades and bombs, because of the risk of collateral damage to others besides the person you're trying to kill in a self-defense situation. I think the collateral damage risk in a self-defense situation is so high it makes it unusually dangerous as compared to like a semi-automatic rifle or a semi-automatic handgun, which is not unusually dangerous. They're just straightforward dangerous, which all arms are. Let's take another example that's also, I believe, covered by the National Firearms Act that likely is also not protected under the Second Amendment because it's unusually dangerous as well as not in common use, and that would be explosive mines. As we know from Lady Diana, who really hated landmines, you can argue the good and the bad of landmines. Obviously, they do protect good people from bad people. But the truth is, it is a fair point that mines don't discriminate between good and bad people. And you may have every good intention of laying down landmines in your home, for example, but there's no guarantee that the person stepping on that landmine will be the bad guy. It could be a fireman or a first responder. And that is why I think explosive mines are potentially bearable. They are bearable, and they're arms. They could be used offensively or defensively. But the reality is, I don't think they'd be protected under the Second Amendment because they're unusually dangerous because, again, of the risk of collateral damage to people other than those who you want to kill, the bad guy. And, of course, they're not in common use, which makes them unusual. On a related note, historically, trap guns, which you sometimes see referenced, is another example of this, where the issue with trap guns is not that the gun is a trap gun. It's how the gun is used. And when a firearm is used in the form of a trap, meaning you take a gun and you point it at an open door and you set a trap, so if anyone opens up that door and it shoots them, they get injured. Trap guns were generally banned because, again, the use of a trap gun or the use of a gun in the form of a trap gun was not able to distinguish between the good guys and the bad guys. You had a high risk of collateral damage to people who are the good guys who shouldn't be shot and you had no right to kill, and that is why trap guns were often banned. The guns were not banned, but the use of the guns in the form of a trap gun, that process, that use was banned. And again, it's further proof that my view that uses of guns or weapons that create a high likelihood of collateral damage are unusually dangerous in the dangerous and unusual standard. Let's take another one. Sometimes you see Judge Frank Easterbrook in the Seventh Circuit ask about handheld nuclear weapons. Well, handheld nuclear weapons or shoulder-fire nuclear weapons, they're bearable arms. Are they protected? The answer is no, they're not. Because they're dangerous and unusual weapons. In addition to the fact that no one owns them and thus they're not in common use, they're also unusually dangerous. Why? Because, again, of the high risk of collateral damage to good people other than the bad people. So I may want to use a nuclear weapon to shoot the bad guy, but the risk to other people is extremely high to the use of a shoulder-fire nuclear weapon. Again, grenades, bombs, explosive mines, shoulder-fire nuclear weapons, shoulder-fire missiles, which I think are also NFA items, by the way. All of these are examples. Incendiary devices, all of these kinds of examples, as I see it, are the sort of thing where if I want to use these weapons in a self-defense context and I want to shoot the bad guy or get the bad guy with this type of arm, because of the nature of the weapons themselves, it dramatically increases the likelihood of collateral damage, meaning killing people or injuring people that I'm not trying to target, because I only have the right under American law of self-defense to kill the bad guy who poses a threat to me or to others, right? I don't have the right to kill others. So if I use a kind of a weapon that blows up like 12 people just to get the one bad guy, well, that's probably an unusually dangerous and an unusual arm of the sort of thing you can ban. Now, that gets us to two other arms that we need to talk about: machine guns and short barrel shotguns. I'm going to set short barrel rifles aside for a moment. I'm going to talk about that separately. Short barrel shotguns and machine guns. Now, you may not like this, but again, you don't turn to this channel for me to blow smoke up your dupa and tell you fantasy things that you want to hear. I'm here to tell you what I think is the reality on the ground. And only if you know the reality on the ground, if you get the diagnosis right of where we are, can you then go out and improve the world. And that's what I'm doing with this long video, so you understand how I think the world functions right now, how it really is right now, and you can go out there and try to make things better. So with that said, how do we deal with the issue of machine guns and sawed-off short-barrel shotguns? I think there's two ways to deal with these in this context of unusually dangerous and unusual arms. Dangerous and unusual arms. First of all let's talk about short-barrel shotguns. We all know that short-barrel shotguns are fantastic weapons for shooting a lot of people fast with a single blast. We know that in Vietnam, for example, it was not unusual for men on the point to carry sawed-off shotguns to the extent they found themselves in some sort of an ambush situation. They could touch off 1 or 2 rounds with a very, very wide, big spread and take out multiple people. And that is probably why you cannot have, or you don't have, Second Amendment protections for sawed-off shotguns, because again, what is my theme here? The high likelihood of danger of collateral damage to people other than the bad guy. If you touch off a round with a sawed-off shotgun, yeah, you're probably going to get the bad guy, but because of the spread of the pellets, whatever you put in there, whatever the load is, you're likely going to increase the risk dramatically of hitting people other than the bad guy, and thus the high risk of collateral damage. Likewise with machine guns, I know this will be the most controversial one, but the reality is with machine guns, I think you can explain this the same way. Because for most ordinary Americans, controlling machine guns with the rapid fire, with a single pull of the trigger, makes it much harder to control, and therefore, consistent with Mark's theory here, the increased odds of collateral damages to people other than the bad guy you're trying to shoot dramatically goes up because of the difficulty in controlling a fully automatic weapon. And again, as we know from the use of suppressor fire with machine guns, it is designed, in fact, to spread the rounds, the bullets over a number of people that you're trying to, let's say, pin down. So I think whether you're looking at bombs, grenades, shoulder fire nuclear weapons, sawed-off shotguns, or machine guns, I think you can lump all these into the category of weapons that can be banned under the Second Amendment because of the high risk of collateral damage. Now, I want to just say one additional thing about sawed-off shotguns and machine guns. This is not about what Mark wants. Never lose sight of that. I'm not telling you what Mark wants, but it doesn't matter what I want. It's irrelevant what I want because I don't control the Supreme Court. I don't control the federal government. So what I want is irrelevant, okay? So with that said, we know based on Supreme Court precedent, whether it be the Staples case, whether it be the Heller case, whether it be multiple other references in like the Bumstock case or Cargill, we know that the Supreme Court has repeatedly said that fully automatic weapons are not protected under the Second Amendment, including Justice Scalia in the Heller case. We also know from the 1939 Supreme Court decision of United States versus Miller that sawed-off shotguns is unequivocally not protected under the Second Amendment by virtue of that Supreme Court precedent. So that is how you handle sawed-off shotguns and machine guns. Now, what about sawed-off or short-barrel rifles? Well, I think that's a different category. First of all, if you look at the number of short-barrel rifles registered under the National Firearms Act, it's a pretty big number. It's well over 1 million, I recall. So it's a large number, so they are really in common use by Americans for lawful purposes. Sawed-off, short-barrel rifles, not to be confused with short-barrel shotguns, which I don't think are protected under the Second Amendment under current law. I think short-barrel rifles is a bit more complicated because really, if you think about it, to the extent handguns are protected arms under the Second Amendment, in the Heller case, likewise, semi-automatic rifles such as AR-15s and AK-47s will likely be protected arms under the Second Amendment because the Supreme Court will just apply Heller and rule the same way. The question is, how is it possible you have long guns in the form of long rifles and you have handguns are protected, but somehow the weapon in the middle is short barrel rifle, which is really kind of in the middle of two things that are protected under the Second Amendment? How can that not also be protected by the Second Amendment? And the answer is ultimately, I think it will be. And again, a short barrel rifle, I think, does not pose the risk of collateral damage the same way that a sawed-off shotgun does, and or a machine gun does, and or a mine does, and or a bomb does, and or a grenade does, and or a shoulder-fired missile, and or a shoulder-fired nuclear weapon. The lack of collateral damage risk in the form of a short barrel rifle, I don't think exists. And that's why I think there's a strong argument that short barrel rifles will be ultimately protected by the Second Amendment in time. Because the collateral damage argument that makes something, I think, an unusually dangerous, in addition to an unusual arm, is much different than dealing with semi-automatic rifles, semi-automatic handguns, AR-15s, AK-47s, and the like. I'll just say one other thing, folks. Some of the anti-gunners are trying to argue that the dangerous and unusual test is really the unusually dangerous test, and they try to conflate all this into a single standard of unusually dangerous. 2 points to that. First of all, it's simply not accurate because the Supreme Court in Hiller literally says the test is if an arm is dangerous and unusual, then it can be banned under the Second Amendment, and the burden is on the government. It doesn't say unusually dangerous. But if you want to argue that a weapon is unusually dangerous and can be banned, it actually doesn't help the anti-gunners at all. Even though it's not the right test, it doesn't help them because an unusually dangerous weapon obviously is the kind of weapon that would be unusually dangerous compared to something that's usually dangerous. And we know that if an arm is in common use by Americans for lawful purposes, an AR-15, AK-47, semi-automatic rifle, semi-automatic pistol, whatever you want to say, these are not unusually dangerous weapons because they are usual in our society. You see? So since they're usual in our society, they're common in our society, the level of dangerousness inherent in the use of these weapons means that that level of dangerousness of those weapons is common. It's not unusual. And therefore, to argue that an unusually dangerous standard standing alone, which is what the anti-gunners want to try to argue sometimes, that an unusually dangerous standard somehow does any work for them. It doesn't, because again, the kinds of weapons they're trying to ban today, semi-automatic rifles, semi-automatic handguns, magazines that hold more than 10 rounds, none of these are unusually dangerous in American society today because everyone has these things, and thus the dangerous level associated with these weapons is not unusual in the least. So even if you hear someone try to say the standard is unusually dangerous as opposed to dangerous and unusual, it doesn't really get them very far at all because, again, once the weapons are in common use, the level of danger inherent in those weapons is in common use, and that's the common level of dangerousness, and thus, by definition, it cannot be unusually dangerous, which again is the standard for assessing the constitutionality of a law dealing with the dangerousness of a weapon as articulated by the anti-gunners. But again, it simply doesn't hold weight or give them the ability to do what they think it does. It's just the best they can do with the standard, and it's not the right standard. And again, it's not going to win for them at the end of the day, even if it were the standard, but it's not. All right, folks, I hope this wasn't too geeky, and I hope this helped you break some of this stuff down. And again, when you talk about the NFA as constitutional or not, some of it probably is, because I don't think, I simply don't see a world in which a court is going to say that hand grenades and mines and bombs and shoulder-fired missiles, for example, or destructive devices are going to be Second Amendment constitutionally protected anytime soon. And therefore, those parts of the NFA are likely constitutional. So if you're going to argue about the constitutionality of the National Firearms Act, you should be very precise as to which weapons you think are constitutionally protected under the Second Amendment and which are not, and be able to explain why they're protected in a detailed fashion. Because mouthing the words shall not be infringed or the NFA is unconstitutional gets us literally nowhere. It's just mouthing words and wasting time. You got to break it down in a much more serious way if you expect to win in this world. And hopefully today's video, albeit long, helps you accomplish that, because I know this is hard, but this is super duper important. And that's why I wanted to spend time with you breaking it down in this super geeky way. Because again, we're in a fight for our rights, and I want you to be the smartest person in the room. And to do that, sometimes you got to put in the work and think hard. Okay, folks, so let me know if you agree, disagree in the comments below. I do appreciate your time on this one. Don't forget to follow me over there on X at 4Boxes Diner, and subscribe to YouTube and to Rumble. I look forward to talking again real soon here at the 4Boxes Diner.
Orders up. Table 2A.